And the Honorable Brian K. Kirkland presiding.
Good morning, Mr. Chapman.
Good morning, Your Honor.
You can go ahead whenever you're ready.
Thank you. I just have some bench warrants for the record.
Okay, we don't have any.
Glenn.
You already did, yeah. Mhm.
Pardon? Okay.
I was just waiting for the jail to come up, but I didn't see him, so I was, what happened?
Yes, this is the one person that was in, you were disqualified for both.
Yeah,
were
I know,
indicted.
I know. Go ahead.
Okay. Glenn Holden. These respondents failed to appear for their respective referee hearings. Front of the court requests a bench warrants issue in each of these matters pursuant to statute.
Court would enter bench warrants for the following individuals: Mr. Holden, Ms. Laxton, Ms. Wilson, Ms. Carter, Ms. Davis, Ms. Wright, Ms. Delvey, Ms. Sanchez, Mr. Shepard, Mr. Richardson, Mr. Kilborn, Mr. Lewis, Mr. Porter, Mr. Rapp, Ms. Condrat, Mr. Moan, Mr. Brad, Mr. Bowman, Mr. Still, and Mr. Taylor. As a result of their failure to appear at their respective referee hearings, the court would set their bonds in the amount of 25% of the outstanding arrears or $500, whichever is greater.
And $150.
Oh, yes. Yep. And the court would also assess $150 in each case.
All right. Thank you, Your Honor.
Okay. Thank you. Have a good day.
You as well.
058 Deandra, Kathleen Campbell versus Galen Campbell Sr.
Good morning to both of you. In this matter, the matter is scheduled for a scheduling conference, and a scheduling conference is whereby the court attempts to put in place various dates and processes so that the case would proceed in an orderly fashion. I'll go to Ms. Campbell first because she's the plaintiff, and then you'll have an opportunity to again respond, Mr. Campbell. So, Ms. Campbell, what issues do you believe to be in dispute in this case?
Yeah, the only thing I would like out of this whole divorce is a DNA test done on my child. That's all I want, Your Honor.
Okay, if you're going to do that, then there's another thing you're going to have to file. You're going to have to file a request. Sir, this is a court proceeding. Do not smoke when you're in this proceeding.
Sorry about that.
There's a process where you would have to do, and you'd have to seek a revocation of paternity. And there are forms available for that. So you can file a motion to determine that the child was a child born out of wedlock in this matter. It's a different proceeding. You can ask for a DNA test at that point, and so we can proceed at that time. But doesn't pertain to this. Are there any other disputes in this case that you're aware of other than that?
No, Your Honor.
Okay. Mr. Campbell, is there anything that you are contesting or disputing in this case? Yes, no, maybe.
Maybe. I don't know.
Okay, well, the court doesn't know either, so, I mean, you're the one that's potentially contesting or disputing things.
I ain't exactly awake, Your Honor. The thing. Trying to get my bearings.
What I'm going to do is I'm going to reset this for a status conference in about 30 days so we can see the progress, see that Ms. Campbell has filed the appropriate paperwork in the other matter. And at that point, maybe everybody will have a better idea as to what is happening in the case and if they're contesting or disputing anything. So,
Oh yeah, now I remember what it was.
okay.
There was a custody thing going on Charlotte because our son recently was living with his aunt, Kathleen's sister. She petitioned because of health reasons to terminate her guardianship over our son, and the state CPS, the courts up in Charlotte, recommended him to be placed back with me because Kathleen was not stable at that point.
Well, what happens, that's a separate proceeding as well. If that was a guardianship, then they would have, if they're gonna place the child with you after the other party has, the guardian has sought to terminate that, that's a separate proceeding. Not to say that we can't address that in this, but it needs to be taken care of in Charlotte where the proceeding will commence and where the court has jurisdiction, and then we can address it. So let's, we'll again put this over for about 30 days. When we're back, we should have a little bit more idea on what's happening with Miss Campbell was filing her revocation of paternity action and on your guardianship case. So maybe we'll have better understanding at that time.
Okay.
Okay, so we'll just set the matter over and we'll see you back in about 30 days.
All right. Thank
Okay,
you.
have a good day.
Thank
You
you.
too.
Let's continue on 8:45 a.m.
Good morning to both of you. I'll start with you, Mr. Eddie. What is happening in the case? You, being the plaintiff, are responsible for filing the various paperwork to get approvals. Have you done that?
No, sir, I haven't. I didn't realize I had to take it to the clerk's office, and that's my fault. I have the paperwork. I just, for some reason, it wasn't clicking in my head that I needed to go and submit that. So that is completely on me.
Okay, what you're gonna have to do is you'll have to submit the judgment of divorce, the uniform child support order, and the judgment information form. Those 3 documents have to be submitted to the front of the court for their approval. Because the court will not enter those until such time as front of the court has approved them.
Yes, sir.
And then once you get their approval, you can have Miss Eddie sign and approve everything. Unless she's done that already, I don't know. But you can get her to approve them, and then at that point, then you can send them into the court. 2 different things. You go into the front of the court. They don't then forward the documents to us. All they do is send us an approval if in fact they approve them. So then you'll have to submit the final documents with us as well, the circuit court clerk's office, so that we get them.
Yes, sir. Understood.
Okay?
So to the court first, and then to the clerk's office.
Circuit court clerk's office, yes.
And sir, I
Has
apologize.
Miss Eddie approved those documents yet?
No, I don't. I have them. She hasn't signed them. No.
Okay. Okay, well, get the front of the court approval. The reason we do that first is that if they don't approve them, then it doesn't do you any good to have Miss Eddie approve them because you'll have to redo them then.
Yes, sir. That makes sense. And there were 3 documents, sir. Could you list those again so I could?
Judgment of divorce,
Yes, sir.
uniform child support order,
Uniform child support,
and a judgment information form.
judgment information. Yes, sir. Thank you. I will make sure I get those done as soon as possible.
Okay. Miss Eddie, is there anything you have?
I do not. I knew he hadn't submitted the paperwork, so I went online and did a request for child support. But if he files that, then I guess that should cancel out.
Okay.
So
What we'll do is we'll reset this for about 30 days to check on it to see what's happening, make sure that there's progress being made. So we'll be back in touch with you and have a hearing and another one in about 30 days.
okay,
Yes,
Thank
sir.
you.
I
You're free to
apologize.
go. Have a good day.
thank you.
Thank you.
9 a.m. The defendant is not here.
Okay, Mr. Swift, what is happening on your case? Have you submitted the paperwork to the front of the court for their approval?
No, sir. Sorry, I misread that. I thought we were supposed to come to an agreement and then get back with you on an agreement, which we have not been able to come to an agreement.
Okay, are the 2 of you disputing something?
Yes, sir. She wants to keep my son away from our daughters. She had accused him of sexual assault, and his case is pending
Okay,
as of right now.
Okay,
So
Okay, is there, well, what we'll probably have to do in your case is we didn't set the matter for a scheduling, or we had it for a scheduling conference previously, and the two of you stated there was no dispute. So we didn't proceed as a contested case. If you're telling me there is a dispute now, we're gonna have to proceed as a contested case, which means that there's much other things that we're gonna have to do, okay?
Okay.
What I'm gonna do is, obviously, the defendant has not appeared. I'm gonna set this matter for a status conference / scheduling conference, and basically order that both parties appear. And that way we can have it proceed as a contested case, and we can get a scheduling order done and then proceed in that way. And we'll set that probably within 30 days. We'll have that particular hearing set up, and then we can go as a contested matter as opposed to a consent matter.
Now, can you please explain that?
Well, if there's a dispute, if there's any dispute, then it's a contested case. It's not gonna be by agreement, and therefore there's a number of other things we have to do. We have to put in place, if there's discovery that's requested, if there are, we would send the matter to mediation, and then we would set a settlement conference. There's a lot of things we do if it's contested that we don't do if there's, again, if the matter is gonna be resolved. Again, last time you said that there were no issues and disputes, so we did not put it on the contested track, so to speak, but now from what you're telling me is we're gonna have to do that.
Yes, sir.
Okay, so we'll bring you back in about 30 days when Ms. Swift can be present as well. And by putting notice that parties have to appear, if she doesn't appear, then you can proceed and default her and all that at that time.
Okay. Now I have just one quick question for you with the matter concerning my son. Is the only dispute that we really have is she doesn't want to have my son around his sister.
Okay,
But like I had said, his case is pending, and right now there is a thing with that case involving him.
okay.
That
Well, hold on. I'm not gonna get into that today.
Okay.
He's not here, and I don't need to know all of that at this point. What we're gonna do, though, is bring you back in about 30 days, and then we can address everything at that time.
Yes, sir. Okay, understand.
Okay?
Yes,
Okay.
sir.
Okay, we'll let you go. You have a good day, and we'll see you back in about 30 days.
Okay, you too. Thank you.
Thank you. Manager. So I think, let me double check here. Ma'am, can you hear us? Ms. Topa?
Yes, I can.
Okay, we're ready to proceed.
Okay. Mr. Lyons, in this matter, you're before the court charged with civil contempt of court due to your failure to pay child support and or related expenses. Upon a first conviction, you could be ordered to serve up to 45 days in jail. If it's a second or subsequent offense, up to 90 days in jail. Do you understand the charges, sir?
Yes.
The court will advise you have a right to an attorney. The court would appoint an attorney to represent you should you desire an attorney. To my understanding, you wish to proceed without an attorney. Is that correct?
Yes.
Are you doing so freely and voluntarily?
Yes.
Has anyone threatened you, coerced you, used any undue influence, pressure, or promises to get you to appear without an attorney?
No.
Court will find that Mr. Lyons does, in fact, freely and voluntarily waive his right to an attorney. Mr. Lyons, I'm going to have you and Ms. Tolf and Ms. Topa, I'll have you each raise your right hand, be sworn in, and then we'll proceed.
Raise your right hand too, sir. Mr. Lunds, do you solemnly swear or affirm the testimony you are about to give shall be the whole truth and nothing but the truth?
Yes.
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 Thank you. Ms. Tolf, you can proceed.
Thank you, Your Honor. We're here today for a bench warrant hearing for docket number 2017 TC involving Robert Lyons after the respondent failed to appear before this court for an adjourned bench warrant hearing back in April of 2024. The defendant's total monthly obligation is $374.50. This comes from $321 for current support. He is ordered to pay $50 per month toward arrears and $3.50 per month for service and processing fees. Last payment we received on this docket was $86.09 back in November 6th of 2019 through income withholding. This is the 5th show cause. He's had 6 bench warrants and no prior contempt findings. I have monitored his compliance for the last 6 months at a rate of $374.50, meaning he should have paid $2,247 and he has paid nothing. Total arrears on this docket are at $25,200.15 through the end of September 2024. When I spoke to the respondent earlier this week, he did tell me that he does have the ability to work and pay on this case. He stated that he does do odd jobs for money. The respondent booked into Calhoun County Jail on September 25th, 2024 and has credit for 15 days served.
Okay. Mr. Lons, do you dispute or contest any of the statements made by Ms. Tall?
No.
Okay. Do you have any questions for Ms. Tall?
No.
What would you like to tell me, sir?
Nothing,
Well,
sir.
Let's start this way. How have you been able to support yourself? You have odd jobs. How much do you make on average in an average month on your odd jobs?
I don't know about average months, but I mean, like on the daily, I know at least make like between like 50 or 100 on a daily. I'm not gonna lie.
Okay.
But yet again, I did have an addiction that I had to feed too. So I mean,
When was the last time you worked a full-time job?
quite some years ago, actually.
How many?
Some years. I want to say back in 2022.
Okay. In the last year, what have you done to acquire employment?
What have I done? I've tried to go get my ID, but every time I try to, it's just something always happens.
So you've been without ID for the last year?
Yeah.
And why haven't you done anything to get it?
Well, from my understanding, I mean, I tried to go through the services that Emily has, like tried to get me to go through. I didn't. It was just like one thing after another. I tried to go to the sheriff center and get an ID. They told me something to do with they couldn't do it for some weird reason. I can't remember at the moment, but yeah.
Okay. Well, you could get if you got a birth certificate, you go to Secretary of State, you could get a license, so you'd have ID. Why haven't you done that?
Certificate right now.
What?
I don't have a birth certificate right now.
Well, I'm saying you can get a birth certificate. You go to the county where you were born and you can get a birth certificate.
Oh, I didn't know that.
Any county you were born in, you just go and you request a birth certificate. They'll charge you a minimal fee for doing that, but it's minimal. I mean, it's like $15 or something of that nature.
I didn't know that, sir.
Okay, well, that's how you get it.
Okay, cool. Well, that's no now.
Okay. Anything else that you'd like to tell me?
No, sir.
Okay. So take it from what you said, because you're working odd jobs and that you don't have any physical or mental disabilities that keep you from working.
I mean, I used to get disability when I was, like under the age of 18, but no, I'm not going to sit there and say that my mental is not the reason why I cannot get a hold of, a steady job.
Okay.
I'm not going to say that.
Okay. Ms. Topa, is there anything you'd like to tell me?
I don't know if there's necessarily anything that I would like to tell you, as I am more intrigued on how we're going to be able to benefit Leland. Obviously, Leland is the one that's suffering throughout this. And as Mr. Lons had stated, he does himself suffer from addiction and has not seen Leland in 4.5, almost 5 years. He did finally speak to him for the first time in 4 years, where I'd finally agreed to allow him to see Leland, because Leland himself suffers from autism spectrum disorder. He is very emotionally attached, and at the thought of his father being present, I guess you could say I'm partially to blame for that, because I very much push that your dad does love you. He's just struggling right now. He's going through a lot. He's going to get it together. So I've kind of aided in that. And my concern is what this will entail for Leland if we're going to see a positive outcome from this and on the behalf of Leland, in the case of Mr. Lons and Leland having a relationship, once we can get something figured out for this, because this has been a long time standing kind of concern with us, and we just kind of want to make sure that we're doing everything we can to benefit Leland.
Okay, well, thank you.
Yeah, absolutely.
Well, what the court will do is the court will make the following finding. In this case, the court's heard the testimony from Mr. Lons. He has stated that he is working odd jobs. He makes between $50 and $100 per day, effectively to support his addiction, not to support his child in this matter. That he, in fact, his last job was back in 2022, that he cannot acquire employment because he doesn't have an ID, but yet he has not done much, if anything, to acquire an ID so that he could acquire permanent employment. The court will find that he's failed to exercise due diligence, failed or refused to comply in this matter, and he is in contempt of court. Mr. Lons, anything before sentencing in this matter?
No.
Okay. Well, what the court's going to do in this matter, I could sentence you up to 45 days. I'm not going to, because it's your first offense. What I will do is I'll sentence you to 30 days in jail with credit for 15 days served. The court will allow you to purge yourself of contempt by paying the sum of $1,000. If you're able to pay that, then you'd be able to get out of jail. If not, then you'll serve the remaining time. Do you have any questions, sir?
No, sir.
Okay, thank you. You're free to go. Thank you, Ms. Topa, for appearing and providing us with some information. You're free to go. Have a good day.
Thank you. You as well.
All right, thank you, Your Honor.
Okay, let's go on to our other. Okay, Mr. Fields, can you hear us?
Yes. Yeah.
Okay, we're ready for your hearing.
Ms. Platic, is Mr. Fields a respondent?
He is.
Okay.
Yes.
Mr. Fields, in this matter, you're before the court charged with civil contempt of court due to your failure to pay child support and or related expenses. Upon a first conviction, you could be ordered to serve up to 45 days in jail. If it's a second or subsequent offense, up to 90 days in jail. Do you understand the charges, sir?
Yes, sir.
Court will advise you have a right to an attorney. The court would appoint an attorney to represent you. Should you desire an attorney, it's my understanding you wish to proceed without an attorney. Is that correct?
Yes, sir.
Are you doing so freely and voluntarily?
Yes, sir.
Has anyone threatened you, coerced you, used any undue influence, pressure, or promises to get you to appear without an attorney in this matter?
No, sir.
Court will find that Mr. Fields does freely and voluntarily waive his right to an attorney in this matter. What we're going to do is proceed with the hearing. So I'll have Ms. Platic, Mr. Fields, and the plaintiff in this matter. Ma'am, if you would raise your right hand, we'll have you all sworn in, and then we'll take some testimony.
Do you solemnly swear or affirm the testimony you are about to give shall be the whole truth and nothing but the truth?
You do.
Yes.
Okay, thank you. Ms. Platic, you can proceed.
Thank you, Judge. We're here on docket 2000 Brown versus Richard Fields. Mr. Fields is here for a show cause hearing. In this matter, this is the third show cause. He's had one bench warrant and one prior finding of contempt. The current obligation monthly is $1,152.50. That's $909 for current support, $240 that should be paid towards the arrears balance, and then service and processing fees of $3.50. As far as last payment goes, there was a payment made on October 4th of 2024 that Mr. Fields paid himself for $800. That is the first payment that's been received since the $1,000 purge was paid on June 4th of 2024. Mr. Fields paid that $1,000 purge in lieu of serving a 14-day jail sentence that was ordered by Your Honor on May 15th of 2024. Compliance was measured over 4 months for June, July, August, and September. During those 4 months, he made no payments. Current arrearage in this matter is $15,575.82 as of the end of September. Mr. Fields does report that he works for General Trucking Incorporated. Our office did send income withholding to them on July 31st. They responded on August 22nd and indicated that he does not work there. He states he does still work there on third shift. However, he's paid nothing on his own, and we aren't able to establish income withholding at this point. The only other information besides the 14-day jail sentence is he does also receive VA benefits as well.
You know how much that is, Ms. Platty?
I don't off the top of my head. I can probably find it real quick though.
Okay, well, I'll ask Mr. Fields and see. Mr. Fields, do you dispute or contest any of the statements made by Ms. Platty?
No, I don't dispute it.
Okay. Do you have any questions for Ms. Platty?
No, just what I talked to her about.
Okay. What would you like to tell me, sir?
Back in July, or when I started working there, it was like the first week of July. I gave her my information and stuff for that, and I hadn't worked for 5 months, so I was basically thousands of dollars in debt. I almost lost my truck, and I had to borrow money from from my family to get by with my bills. I first started working. I'm not trying to not pay it at all. They sent it back saying I didn't work there, which is not correct. So I've basically been dealing with my bills and everything, and I wondered what was going on myself. And it didn't happen, so I just ended up paying some of my bills that I had or I would have lost my truck and everything. So I just made a payment, and I can pay it I can make up both months by 1.5 months, probably the end of the month. I mean, I can make payments every week. I was having an issue with driving to Battle Creek because I drive for a living. It's like 13 hours a day, so I'm usually bedridden because I'm a disabled vet because I have a spine disease in my back. So I'm basically, I don't do much after that. So I procrastinated. Yes, I should have drove down there, but I just learned I can pay it at the Dollar Tree that's down the road. I didn't know that, or else I would have made a payment before that. And I'm not trying to get out of it or nothing. I was just, for some reason they did it. I sent my copy that they gave, that you guys mailed me, to my accountant, to our accountant. So it'll start coming out of my check this week, and I can make up the 2 months by the end of the month for sure.
Okay. So you have, so you're still working there, apparently, but they don't know that?
Yeah, I'm working. It's a big company. I think there's like 2 companies in one. So our accountant's name is Tom. Some guy named Joseph sent it back. I don't even know who that is, but yeah, I mean, my accountant, he'll get right on it because I didn't know where my copy was, and I just found it, and I just scanned it and sent it to his email. So it'll start coming out because it's the same copy. I got a copy, and then they get a copy. So I just sent them mine. So it'll start coming out immediately.
Okay.
Until it does, I can make the exact payment every week at the Dollar General. Didn't know I could do that because I had a problem with the online thing.
How much do you make in VA benefits, sir?
2,684. month.
Okay. But clearly with that in your job, you have sufficient income to pay your support obligation.
Yeah, I do.
You've stated that you'd be able to pay up the 2 months you missed. So what you're looking at is $2,305. You understand that?
Yes.
And you can pay that by the end. When you say the end of the month, you mean the 31st?
Yeah, yes. You said 23?
$2,305.
Yeah, pretty close. I'm not doing the math in my head right this second. I'm not sure because I lost a couple of days last week or whatever. This week I took off, but yeah, it'll be pretty close to that. Not more than a couple bucks, but I'll try to get it all in there.
Okay. Ms. Brown, is there anything you'd like to tell me?
No, sir.
Okay, thank you. Thank you for taking the time to appear. Court will note in this matter that Mr. Fields has testified that he, in fact, does work for General Trucking, making, again, sufficient income to pay his support obligation. He also has VA benefits of $2,684 per month. So clearly he's able to make support payments. He has not done so, although he did make a payment on October 4, 2024 of $800 in this matter. So the court is taking that into consideration. He stated that he now knows how to make the payments locally where he is, such that he'd be able to make those payments and would not be delinquent. He said he's provided information to his employer, so they should begin taking it out of him. But prior to this time, the court will note that he's failed or refused to pay, and he has not had any basis to do so, notwithstanding the fact he does get VA benefits. He says he is capable of working and has, in fact, worked and able to make the payments. So the court will find that he's failed to exercise due diligence, failed or refused to comply, and therefore he is in contempt of court. Anything, sir, you'd like to say before sentencing?
No, sir.
Okay. Well, what the court will do in this matter, because you said you can pay that amount, and obviously what we want to do is we want to get it paid so that the Miss Brown is able to support the child or children, as the case may be. What we're going to do is the court is going to, in this matter, you previously had a 14-day jail sentence for a contempt. What I'm going to do in this particular case is the court is going to sentence you to 30 days in jail with credit for no time served. The court is going to suspend that jail sentence until November 1, 2024 at 4:00 p.m. What happens, the courts allow you to purge yourself of contempt by paying the sum of $2,305 no later than the November 1st date. If you pay the money by that date, then you would not end up having to go and serve the 30 days. Do you understand that, sir?
Yes, sir.
Okay. You said that you'd be able to pay that, so the court's going to take you at that. You pay that, and then you understand you're going to have to start paying your regular monthly amount, or you're going to be back here just a couple months. You understand?
Yes, sir.
Okay.
It won't happen again.
Okay, well, we'll let you go, and hopefully we don't see you back, and you make the payment, and then you won't have to serve your time in jail.
Okay, thanks.
Thank you, Ms. Brown.
Yeah, bye.
Free to go, and thank you, Ms. Bladdick.
Thank you, Judge.
Jenny Egan
Thank you,
versus
Judge.
Eric Lind. Attorney Magnuson for the front of the court office.
Good afternoon to everyone. This is time and place up for the evidentiary hearing on the action filed by defendant again for revocation of paternity in this particular case. Mr. Lind, are you ready to proceed?
Yes, sir.
And Ms. Egan, are you ready to proceed?
Yes.
Court will note the appearance of Mr. Magnuson on behalf of the front of the court's office. Mr. Magnuson, do you wish to, I guess, question the parties in this matter?
Yes, I'll do that, Your Honor.
Okay, thank you.
So we just swear who's,
Have they been sworn?
We'll start Mr. Wallind in first.
okay, please raise your right hand, Mr. Lynch. Do you solemnly swear or affirm the testimony you are about to give shall be the whole truth and nothing but the truth?
Yes.
Okay, go ahead, Mr. Magnuson.
Mr. Lind, can you hear me?
Yep.
Okay. So, Ms. Egan is the mother of the child, Marianne, is that correct?
Yep.
And when was that child born, do you know?
I don't recall off the top of my head.
Okay. Did you sign an affidavit of parentage indicating that you were the father of that child?
I did, but only because I was unaware of exactly what I was signing. I should have asked more questions, but I didn't.
Okay. And you brought this motion to revoke the affidavit of parentage and disestablish you as the father, is that correct?
Yes.
Okay. Would it be correct that the child was born sometime in February of 2022? Does that sound right?
Yep.
Okay. So conception probably would have been sometime around May, early May of 2021. Does that sound right?
I believe so.
Okay. Were you having sexual relations with Ms. Egan at that time?
I can't recall exactly, but I don't think so.
You don't know when the last time when that stopped, would that be correct?
Yeah, it was. I can't remember exactly when it was.
Okay.
Being honest.
And you understand that if this motion is granted, you'll have no rights or responsibilities as to that child?
Yes, sir.
Thank you. I have nothing further.
Okay, thank you. Ms. Egan, we're going to take some testimony from you, so if you would raise your right hand, we'll have you sworn in, then we'll proceed.
Do you solemnly swear or affirm the testimony you are about to give shall be the whole truth and nothing but the truth?
Yes.
Okay, go ahead, Mr. Magnuson.
Ma'am, can you hear me okay?
Yes.
Now, you are Mariana's mother, is that correct?
Yes.
And what is her birthday?
2022.
Okay, so conception would have been somewhere around May of 21. Does that sound
Yes.
about right? Okay. And were you and Mr. Lint having sexual relations at that time?
Yes, we were actually in a relationship living with each other at the time.
Okay. And you eventually separated?
Yes.
Okay.
We've been separated for 2 years, a little over 2 years.
And you and he did sign an affidavit of parentage around that time, is that correct?
Yes.
When did you sign? Did you sign that at the hospital or
Yes.
a little later on? Okay.
We signed it at the hospital on the day I left the hospital, which would have been like February 5th, February 6th.
Okay. And Mr. Lint brought his motion and you and he and the child participated in genetic testing, is that correct?
Yes.
Have you received a copy of that result?
As far as I know.
Okay. You've seen it?
Yes.
Okay. And it indicates a 0% probability of paternity? Is that correct?
Yes.
Okay. Do you know who the father is of the child?
I have somebody in mind that I am working with right now, but I am waiting to hear back.
Okay. Do you know that person's name?
Yes.
Who is that?
His name is Devontae Jackson.
if the court grants Mr. Lind's motion, would you be willing to cooperate with our office in establishing paternity in this
Yes.
case?
Yes, I will.
Thank you. I have nothing further.
Ms. Egan, just to clarify, you said that the affidavit of parentage was signed, you felt time you left the hospital, but if the records show that it was signed on February 3rd, 2022, would you dispute that?
I signed mine as soon as I signed all the paperwork. So I don't remember exactly what day I signed mine, but I know he came up the day I was leaving the hospital to sign his paperwork.
Okay. Well, I'll tell you just so the records show it was on February 3rd, 2022. So
Okay.
I don't know if your testimony may vary from that, but it shows if he signed it at a different date, he put the wrong date on. I don't know.
I actually have a copy of it so I can look. Sorry about that.
Well, that's fine.
It says that we signed it February 4th.
Okay.
I have it right here in writing.
Then the petition in this matter is incorrect because that states it's on the 3rd. So, but never mind. That obviously we've got the date on that. Okay. I have nothing further than anything else. Well, let's just address that, Mr. Magnuson. You do have the DNA Diagnostic Center report in this matter. Do you wish to move for that mission at this time?
I would, Your Honor. Thank you.
Okay. Mr. Lint and Ms. Egan, do you have any problem or objection to the court accepting the DNA Diagnostic Center report dated April 2nd, 2024?
No.
Okay. Mr. Lind?
No.
Okay. Court will admit the DNA Diagnostic Center report signed by Deputy L. Kumar, PhD, Lab Director of the DNA Diagnostic Center, showing a probability of paternity of 0%. Anything else, Mr. Magnuson?
No, Your Honor.
Okay. Court has heard the testimony in this matter, and obviously the testimony from all the parties are that the defendant signed the acknowledgement of paternity, believing that he in fact was the father of Marianne. In fact, it turns out there was some question at some point, and again, the parties submitted to DNA testing, which, as I stated, came out with a probability of paternity of 0%. So based upon that, the court will find that, in fact, Marianne is in fact a child born as out of wedlock and not issue of this marriage, and will be excluded, and the defendant will be determined not to be the biological father of Mariana, and will enter an order consistent with that. Ms. Egan, if you wish to get that order, you can probably get it anytime after tomorrow or tomorrow on, because I will sign it, but I've got a number of hearings after this that I have to conclude before I can get to that.
Okay.
So this is an FOC case, so Attorney Madison has to prepare that order. We don't have the generic one in file.
Oh, we don't have it.
No.
Yeah, I was going to ask that question, if the court had their own order ready,
No.
or if I needed to prepare something.
We'll need you to prepare that, Mr. Magnuson. We usually, when a party files, usually they have, it's in the file, and it's not that I'm aware of.
Yeah, we don't for sure. Yes. Because this case was reopened at FOC's motion, and so we'll let them prepare.
Oh, okay.
Yes.
Oh, that's right. I remember
Right.
going back through this. It was dismissed, and then we reinstated the case.
Yeah, this
That's
case, yeah, there's a bit of a difficult procedural history here, so I'd be happy to prep that.
Okay. Thank you. If you would submit it under 7-day, we'll be able to get that entered and get that concluded. So, ma'am, it'll take a little bit over a week now to get that done then.
That is okay, sir.
Okay? Thank you both. You're free to go. Have a good day.
Thank you.
All right. Thank you.
Thank you, Your Honor.
Yep.
Here for a moment versus Evolutions Holding and for other defendants. Attorney Polderman for the interested party. for his show cause motion against defendant Matthew Lavender pro per.
Good afternoon to everyone. Court will state that this matter is before the court on the receiver's motion to show cause. Mr. Polderman, just to ask, have you had any contact with Mr. Sobchak? He's not here, and I didn't know if you knew if he was going to appear or not.
I have heard from him today. I don't believe he's appearing. He did not say one way or the other, but our discussions led me to believe that he was not going to be appearing today.
Okay, well, I know he hasn't appeared yet, so if he comes in, we'll let him intercede. But at this point, what we'll do, Mr. Polderman, you can proceed with your motion.
Thank you, Your Honor. I don't have, as I'm sure the court's had a chance to review the pleading. This concerns the return of $85,000, approximately $86,000 to the receivership estate. This happened almost concurrent with the appointment of the receiver. I brought it to Mr. Lavender's attention. We had worked out a stipulated order for a repayment plan, which was attached as Exhibit A to the motion. Mr. Lavender has indicated that he simply does not have the funds, that he took them and applied them to another business and its expenses. And he has made two offers to resolve this. The first offer was payment of $5,000 a month. Unfortunately, by my calculations, that's going to put us out almost, I think, 18 months to pay this. And I'm hoping this case doesn't drag on that long, but we need to resolve this sooner rather than later. The business is kind of hand to mouth. And $86,000 would go a long way to stabilizing operations. So $5,000 a month doesn't really work from the receiver's perspective. The other offer that Mr. Lavender made as recently as yesterday, I actually met with him on site to try to resolve this, was he has some personal motorcycles that are free and clear, and he would offer us a lien on those while he paid the $5,000 a month. But $5,000 a month is just too long of a payment term, and the amount is substantial. If we were talking $15,000, it would be one thing, or if I knew that the estate would be made whole in a matter of, I don't know, 4 to 6 months, that would even be worth considering, but I just simply can't go 18 months. And I also noted in my motion, right, civil contempt can involve a number of remedies. I don't particularly want to see Mr. Lavender incarcerated. I don't think that necessarily gets us our funds faster. But the court also has to make a determination if there's a manifest hardship and his financial resources. I'm obviously aware of his 3 motorcycles. He disclosed those to me, one of which I think is titled in his wife's name. I do know that I did terminate Mr. Lavender's, or my client did, Mr. Bullock, terminated Mr. Lavender's employment at Evolutions Grow probably, well, I think it was the beginning of September. So he is not receiving a salary from the receivership estate. And Mr. Lavender also offered a lien on his residence. The problem with that is that Mr. Trainer, as part of his Ann Arbor litigation, has recorded a lis pendens against the house, and the house is also owned by Entirety's property. And I'm told Mr. Lavender's wife would sign off on such a lien, and the lis pendens isn't necessarily a lien or a right to payment, but we would be behind that. So that was kind of cold comfort as far as some sort of security. So that's what we're asking for today. Repayment of the exact amount is $85,883.55. And then the court awarding such relief as it deems appropriate under the circumstances.
Okay, Mr. Polderman, when I read through the pleadings, I was a little bit confused, only because then you brought up a sum of $142,088.04. I'm thinking, where did that come from?
So that was the original amount, and Mr. Lavender actually did pay $50,000 towards that. So he did do that. So that reduced it to the it was a little more than 86, and then I gave him credit for an insurance payment. So taking into account those two things, it reduces the balance to the roughly 86,000.
Got it. When I was looking through that, I couldn't see where that had come up. Mr. Lavender, what's your response to the motion?
I don't deny what Mr. Polerman says. I've been working with him on it. You know, I personally, I put that money into the company knowing that Mr. Bullock and Mr. Polerman were taking over in a matter of a week and a half, and I put that in so the company made payroll, or it would have been out of business before they even got there. So I was trying to preserve the asset for the benefit of the investors, for the benefit of Pelorus, and the benefit of everybody. Because had I not put that in, and the only reason I put it in was that I was promised I'd get it back before the receiver took over, was so that we made payroll. I feel that we could, mediate this if John and I had a little more time. I feel like, we have hearings that are coming up on the Liz pendants because it's, I don't feel it's legit. I've loaned the company tons of money. I'm not getting it. And I'm doing everything I can. I still work for the company, even though I'm not even getting a paycheck. So that 5,000 was the best offer I could do at the time. But if you said he gave me 6 months, a lot of things will be straightened out in 6 months.
Okay. Mr. Matheson, on behalf of the interveners, do you have anything to add?
Nothing, Your Honor, just mostly observing here. Thank you.
Okay. Well, based upon what's been stated today, the court does note it does appear that Mr. Lavender maybe had the best of intentions, but he did divert or otherwise remove assets belonging to the receiver estate in this particular matter. So I'll ask you, Mr. Polerman, but the intent of the court is ordered that you would have a right to a writ of attachment, execution, and / or garnishment of Mr. Lavender's assets in the amount of $85,883.55, which will allow you to proceed and attempt to collect that. Is there anything else that you desire today?
Your Honor, I guess just to clarify that, and I think I did propose that effectively. I mean, if it's a writ of attachment, execution, and garnishment, that sounds pretty much like the authority that a receiver would have. Just for sake of simplicity, would Mr. Lavender's assets be added to the receivership estate until such time as that 86,000 is satisfied?
Well, what I'm doing is allowing you to go after those particular assets. So it'd be allow you to get those and bring those into the receivership estate to the extent of the $85,883.55. I don't know that I could do a blanket, seizure, if you would, of all of the assets, but you have a right to collect against those assets at this point.
Okay. I think I understand. I can prepare an appropriate order that would reflect that.
Okay. Anything else, Mr. Polerman?
No, Your Honor.
Okay, Mr. Lavender, anything else?
No, sir.
Mr. Matheson?
No, thank you.
Okay, we'll conclude this matter at this point. You're free to go. Have a good day.
Thank you.
Thank you,
Your
Your Honor.
Honor.
Before at 1:43 p.m. Attorney Reed for the plaintiff. The defendant is not here.
Okay. Again, good afternoon. This matter is before the court for evidentiary hearing on the plaintiff's motion to set aside referee order in this matter. I've read through all the pleadings in this particular case. I'll kind of tell you what my thoughts are, Ms. Reed, and then I'll let you proceed if you have some, dispute with that.
Great.
Okay. Court notes that the order provided if the father educates himself as to how to care for Dantel Jr.'s asthma and hearing condition, then beginning 10/15/24, father will have unsupervised parenting time on alternate weekends, Friday to Sunday at 6, in addition to the Wednesday. What the court was going to order in this matter, based upon my reading of all the pleadings in this case, is first that I think you would ask for, and I think the court believes that that's appropriate, is that the defendant would in fact have appointments set up and meet with, I think both doctors, because I think the asthma and the hearing are separate. Is that correct?
That's correct, and your honor already made that determination at the motion hearing and we
Okay.
submitted an order under
Okay.
7-day, and that was entered 9/23. And so in that order, the court addressed the communication app, defendant meeting with the child's doctors before commencing unsupervised parenting time. His supervised parenting time is going to continue. And then today is primarily about the child support issue and his ability to work.
Okay, thank you, because in the paperwork I had, I didn't see that order, so I don't know if it didn't get processed fast enough or in the file or whatever. What is your, I guess, your desire as to the imputation in this particular case?
We're looking for a minimum of at least $15 an hour. This defendant does have an ability to work. He has a history of working with the factories. He's voluntarily unemployed or underemployed. He testified at the referee hearing that he was working at Wing City and only making and doing like part-time employment to the extent to only pay for his child support obligation. And that's why the referee ordered the child support amount as is. And I don't think that's appropriate, as it was only part-time to cover that child support obligation. I understand he has pending charges at the time or right now, and he has a upcoming preliminary exam, and I don't know where that's going, but right now he is on bond. He has an ability to work. We have no information about any sort of mental or physical impairments or any sort of obligations that prevent him from working. So we are requesting that he be imputed at 15.
Okay, court will note that it's now 1:47 p.m. and it was set for 1:30. The defendant has not appeared in this matter, nor has the defendant filed anything in this matter which would dispute or contest his ability to work in this matter. So the court oftentimes does impute income of $15 per hour because of most of the factories and other businesses will pay that in this locale. So the court does believe that that is an appropriate amount to impute, which the court will do, and impute that to him as he is voluntarily underemployed in this matter. As stated, the court did note the record showed that he did testify that he's working, I think it was at Wing Street is what you said, and that he in fact was there sufficient amount of time to get money to pay the support obligation, but that doesn't assist in making a, I guess you'd say, a reasonable determination as to what the support should be, only as to what it is. And so the court will allow you, Ms. Reed, to impute the income at $15 per hour at full-time employment, and therefore you can recalculate the support based upon that, submit a uniform child support order in this matter, and the court will enter that. You can submit under 7-day.
Thank you.
Anything else?
I do not believe so.
Okay, thank you. You're free to go. Have a good afternoon.
You too as well.
All right, we'll close it here.